Okay, before we begin, in one new tab, or as soon as we finish these directions, in a new tab, you're going to open a Google Doc that lets you take Sixth Amendment notes. Please note you can pause the video anytime, go to that new tab, and fill out the activity as you're asked to. And then finally, in another new tab, go to tinyurl.com/cc6am and copy the text of the Sixth Amendment onto your notes page. The Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The first section that we're going to highlight is a speedy trial. A speedy trial, the whole point of it is to stop the length of time from being ridiculously long before a trial. So if you're arrested for something, the time that you're arrested between that time and the time your trial actually begins isn't wicked long. Sometimes that's not really possible to avoid, but we really try as best as we can. We also want to minimize anxiety about public accusations, so the less time that transpires between the trial, or between the arrest and the trial, the less time the public is to taint itself, to make accusations on its own without the government. And I mean, ironically, now we have Twitter and Facebook and Instagram and Snapchat and all sorts of different things that allow us to immediately share information and ideas. So without even realizing it, our founding fathers back in 1787 had a really good idea here. We don't want a lot of time passing between the arrest and the trial if possible. It's also important to recognize that if you have a delay between the time of the crime and the trial, the quality of defense can actually go down because witnesses' memories can become sketchy. Eyewitness testimony is already difficult just because there's impulse of the moment and adrenaline, and different people might see the same person and say that he's anywhere from 5'2" to 7 foot tall and wearing red or orange or green, and it's really hard. So the longer it is that we have to rely on people's memories, the more challenging it can be to have a good defense. How do you determine if a constitutional challenge exists as far as a speedy trial? Because you're right, sometimes there's a long length of time between the time you're jailed and the time that you are on trial. If it's extremely long and the reason for the delay is determined to also be prejudice to the defendant and the defendant's claim of that right. So if the defendant can claim, I had a really poor trial, it prejudiced me because it took too long, this is why, then they might be able to have a speedy trial claim. It's challenging because sometimes it's about testing evidence, sometimes it's building a case. And if the prosecution is actively building a case, it's not necessarily going to be quickly, but that doesn't mean that they're dragging their feet either. So how speedy is speedy? In some cases, a month. In other cases, not so much. So what you're going to do is pause the video, and in a new tab, go to Google, search for one of these 4 trials, the McNeil trial timeline, the Simpson trial timeline, Zimmerman trial timeline, or Bulger trial timeline. Type in all 3 words, the name and then the word trial and the word timeline. Review what you find, add a link that you're using into your notes, and then write a quick overview of how long it was from the time of the crime to the investigation to trial. And then when you come back to the video, you'll see a question that you can answer and then continue. Our next key point in the Sixth Amendment is public trial. The public trial helps assure that the defendant gets a fair and accurate adjudication of guilt or innocence, or determination is another word for adjudication. Basically, the public, it's supposed to keep people, the public is supposed to discourage people from lying because they're in public. It's supposed to keep judges on their best behavior. It's supposed to not let prosecutors push buttons, because if you're doing something in public, people can hold you accountable. If it's in secret, you could have bias or you could have some sketchy going on. So public is very important. There's also a right to the press to be at every trial, and that's supposed to be the representative of we the people who can't be there at the time. So it's part of the free press in the First Amendment, and it's part of our public's rights to knowing what's going on. And it's important to note that juvenile proceedings are an exception to this. We always protect, to the best of our ability, the identification or identities of juveniles. An impartial jury, that basically prevents the government from doing whatever it wants. If they have to present a case to a bunch of people, 12 people, then those 12 people aren't part of the government, so the government can't be just picking on random citizens. If you feel that you don't need a jury trial for whatever your situation, you can waive that right. You would then have what's called a bench trial. A bench trial is when a judge listens to the case as opposed to a jury. Thus the bench, the judges sit on a bench. And when it says an impartial jury of your peers, peers don't necessarily mean their same age or neighborhood, but it needs to be a random selection that gives you a cross-section of society in the area in which the crime was committed. Jury selection, we'll talk a lot more about this next week in class, and we talked a little bit about it with grand jury selection. It's the same process. It's from driver's license lists, voter registration lists, and government ID lists. And it's completely random from the time that you're 18 forward. In being informed of your accusation, this one is really just straightforward. The government has to tell you the nature of the charges against you. What are you being put on trial with? That makes sense, because if they don't tell you what you're on trial for, how are you supposed to mount a defense? The next section is confronting witnesses. We have the right to confront witnesses. That's through direct examination, where you ask friendly questions of your side, and cross-examination, where you interrogate the other side. We'll talk more about that in just a little bit today. Face-to-face confrontation is not required if someone is accused of doing crimes against children, like sex crimes against children. Those children do not have to testify in front of the person who allegedly hurt them. We want to again protect the children. The phrase obtaining witnesses through a compulsory process. Suspects and defendants have the right to subpoena or require people to bring witnesses or information forward. And if you're subpoenaed, you're mandated to go to court. So what I would like you to do in another tab, you're going to pause the video again. You're going to do a quick Google News search. Find a story that involves a witness subpoena. Watch how you spell it, please. And then put the link in your notes and a brief explanation of it. When you finish that, you can come back to the video and continue. Then there's assistance to counsel. This is our last phrase for the Sixth Amendment. It's an absolute right to an attorney, and it begins after the criminal case begins. So a lineup, custodial police interrogation when you're being interrogated, felony trials, guilty pleas, sentencing. Those are all included. Not included of being required to have a lawyer is if you're doing a photo lineup, like someone walks up to you and says, do you recognize the person in these pictures? A pre-charge lineup, can you pick out the person who did this to you? You're not charged yet. If you're getting a handwriting, finger writing, or voice sample, things that can't be tampered with, and if someone's doing a probable cause hearing of some sort, you're still not charged. The moment you're charged and arrested officially, then it becomes you're required to be offered a lawyer. It can be waived. You don't have to take your assistance of a lawyer. You could do it yourself, but really it's not a good idea. Even if you're a lawyer, a lot of times you shouldn't be your own lawyer. Okay, our last big point then, what I'd like you to do now is go to Haiku, copy the URL of this presentation. It's under today's notes. Add it into your notes, link to it so that you have the description if you need it. And then you took notes for the Fifth Amendment and for this amendment. I'd like you to make those public with a link. Go back to our little turn-in place on Haiku. Let me know if you have questions. And then please look over the directions for your last individual challenge. That's the Sixth Amendment public service announcement. Thank you very much. And we'll do all that before lunch. And then when we come back, we'll get into our mock trials.